Court of Appeals Division 1 is now in session.
Thank you, folks. Have a seat. And good morning, as we get ourselves set up here in a moment. We are here in oral argument on Phoenician Equity Income Funds, LLC, v. Dreambrands, Inc. For the oral argument, the proceedings, I should actually say the case number 1CA CV240917. Sorry about that. These proceedings are being video and audio recorded. They are being live streamed. So please, as you come up to the podium, identify yourself and your client so we know who's speaking and so the folks who are observing it also know. Each side has 20 minutes, as you're well aware. You can see the time on the time clocks. You're responsible for watching that time and keeping track of it. If you wish to reserve any time for rebuttal, counsel, that is up to you, and you're the one who needs to do it. You're welcome to tell us, but we're not going to protect it for you. Also, please keep in mind, we have read the briefs, I promise you. We conferenced the case just this morning, and so we are well aware of the record and the facts. So what we want you to do is focus your argument. You do have the 20 minutes. You're not obligated to use it all, but use the time you feel you need. With that, counsel, you may proceed.
Morning, Your Honors. Morning, Your Honors. Jimmy Purcell, Quarles and Brady, on behalf of Dreambrands. Where I'd like to start this morning is the importance of the issue that we're talking about today. There is probably a temptation to look at this as a simple discovery dispute, whether or not documents get produced between two parties, and think of it in that manner. But in reality, this is an important topic for the corporate practitioners in Arizona. The legislature has enacted ARS 10-1601 at SEC that defines when shareholders in a corporation can obtain records from that corporation. They put restrictions on that in the form of percentage of stock, length of ownership. They have divided the records into two classes that can be inspected and copied simply by asking versus another set of records that can only be copied upon showing of a proper purpose and that those records are directly related to that articulated purpose. In this case, what Phoenician Equity is asking for is a judicially created exception and workaround to those requirements that the legislature has set up and carefully balance the rights of the shareholders versus the rights of the corporation.
How so? What have they asked for that they're not entitled to under the statute?
Under the statute, it's limited to certain financial documents, shareholder agreements. There's a laundry list there. I think in the briefing, Phoenician Equity has conceded that their subpoena goes well beyond that. It goes into many of the business records and internal documentation that is outside the scope of things like shareholder agreements under 10.732, which are very specific types of shareholder agreements. It goes outside the scope of the last 3 years of financial records.
So let me ask you then, are you saying that Rule 27 is unconstitutional, runs afoul of the separation of powers somehow? Because I mean, it is a discovery rule, so I'm not quite sure what your argument is.
The argument is not that it is unconstitutional. It's that...
Does it have to, can they only get what they get under the statute then?
Correct, unless they make the showing that's required under Rule 27, and that's really the core issue.
Which is that it could create a delay in justice or involve that?
No, Your Honor. The requirements under Rule 27 are limited to situations where there is a risk of loss of evidence. The original Rule 27 applied, and this is true in the federal system as well as in the state system, applied to depositions, and it was used when somebody was terminally ill, when somebody may be leaving the country. It needed to be preserved in order not to lose it in the future in case there was, litigation that was contemplated at the time actually materialized. The 2017 amendments simply added the ability to obtain documents the same way, but the requirements that it be to preserve evidence remain in Rule 27. And the issue here is Phoenician Equity's petition is internally contradictory. It pays lip service at best to the idea that documents might be lost or need to be preserved, and doesn't make the required showing under the rule. I think
what required showing are you saying they need to make?
Well, the rule includes 5 things that need to be included in the petition. They need to be able to show that they expect to be a party to an action that can't presently bring or cause to be brought. 2, they have to identify the subject matter of the expedited action in the petitioner's interest. They have to show the facts that the petitioner desires to establish, identify the name or description of each person whom the petitioner expects to be an adverse party, identify the name and address of each person from whom discovery is sought and the evidence petitioner expects to obtain, and then the court has to be satisfied that perpetuating the testimony or preserving other evidence may prevent a failure or delay of justice.
But didn't the court make that finding here?
The court made that finding in general terms, but the court made no findings of fact. And to the extent that the court decided it on this record, we contend it was an abuse of discretion. I think that the court...
Did you ask the court to make specific findings of fact and conclusions of law?
We did not.
Okay.
And the rule does not, Rule 27 does not state anything about findings of fact and conclusions of law, correct?
Correct. But the issue here is if the court can simply rubber stamp using the magic words any petition, then this is going to open the floodgates for pre-litigation discovery in virtually all cases. Simply reviewing the petition in this case reveals that Phoenician Equity essentially argued we need this discovery in order to frame a derivative demand, which is under the federal precedent. Ashby Court is a case that we cite that addresses it directly, is not a proper use of Rule 27. Now, in the petition, Phoenician Equity says we're not doing this to frame a complaint. But in their very first element under A, where they're talking about not being able to bring the action, they say we can't bring this action because we don't have sufficient information to draft a derivative demand, which ignores that, that's one of the issues in the federal.
Mr. Purcell, is it your position that that we don't have enough information under Rule 11 to bring a lawsuit, that can never be the basis for a Rule 27 petition?
No, I think that you need to have enough of a basis in order to engage in this process to begin with. They expect to be a party to an action cognizable in any court. Well, you may not have quite everything that you need, but you can have enough, and you have to make enough of a showing in order to satisfy this requirement that there's actually a cognizable action out here.
And your burden here is to show us there was an abuse of discretion. The trial court could not possibly have reached the conclusion that they made that showing under the facts, under the petition before us in the argument, the hearing that happened. How was it an abuse of discretion? You may disagree. I may disagree. But how is it an abuse of discretion?
It's an abuse of discretion because the court did not apply the proper standards of law. They applied Rule 27 in a situation without any findings regarding preservation, and in a situation where the
But the
petitioner...
provision does talk about preservation. The provision talks about your client's past history of record keeping and some of the challenges with record keeping. So there is evidence, and showing whatever we want to call it, before us and before the Superior Court, that preservation was an issue and a concern.
But preservation can't be an issue in this case based simply on, using the magic words that we're afraid that they're going to destroy the documents. There's no specific facts that are alleged in this
Well,
petition.
some of their problems that they had made the request for documents that your client hadn't bothered to provided pieces, not all of it. And isn't that enough to create some concern that maybe records aren't being kept the way they should? At least to the point that I can't say the Superior Court abused its discretion in reaching that conclusion.
No, I don't think so, Your Honor, for the simple reason that in responding to the initial request, as we explained in the briefing, 2 years ago, incidentally, and we still don't have any litigation that they claim was on the horizon. In responding to those requests, what we did was the original request did not state a purpose. The statute requires the statement of a proper purpose and an explanation of why those records meet that purpose. But under 1601E, there are a series of records that are required to be kept. What we did at that point was produce every record that existed that was responsive to 1601E and invited Dreambrands to explain the proper purpose, and then we can talk about, the records that you need for that purpose under 1602B. They need to make the showing under 1602C. Now, what Phoenician Equities argues is there are all these documents that we think exist that they didn't produce, but thinking a document exists and it not being produced is not evidence that it ever did exist. For example, they talk about shareholder agreements. Shareholder agreements under the statute are not agreements simply with any shareholder, for example, an investment agreement. They're agreements under 10732 that create special classes. They're narrowly defined. None of those agreements exist. Phoenician Equity assumes that they exist, believes that they exist maybe, but they don't. We produced...
But isn't then what's going to happen is the subpoena will be issued to your client, you have no documents responsive to that particular part of the subpoena, and then that's your answer.
For that section, yes, but the subpoena doesn't simply ask for what's under 1601E, and that's the problem.
But is it your position that Rule 27 is necessarily limited to those documents that are in Title 10, that statute? Can you only ask for, through a Rule 27 petition, those documents which are...
That's not our position, Your Honor. Our position is this, is that the court, under the rules of this rule, under the way that it's been interpreted, has a duty to gatekeep and not simply rubber stamp Rule 27, because there are other mechanisms in place to allow for the preservation of evidence. This is not about preserving evidence. Phoenician Equities doesn't want to preserve this evidence. They want the documents, and they want it in order to frame a complaint, which is exactly what is included and what is stated in the petition. And so if they are going to invade the province of what can be obtained from a corporation by a shareholder that goes beyond 10-1601 et sec, they need to do so with an actual showing as opposed to paying lip service to the various elements in an internally inconsistent manner.
And I guess my problem is the Superior Court here found they met the showing. I've got to find an abuse of discretion that there's no way the Superior Court could reasonably have reached that conclusion. Mm-hmm. To do that? That's the struggle, because having sat on that court, I do understand that I have to exercise that discretion, but it's not something we second guess.
Okay, so let's go through the requirements of the petition. The rule sets forth what requirements must be put in this petition. And it is...
Did you move to dismiss the petition? because you could have, and said that it didn't adequately meet it. So we're not here on a motion to dismiss kind of thing.
Well, we opposed the petition. There was an order set. We argued these same points to the
Right, I'm just
trial.
asking, because one of the options would have been to move to dismiss because it fails to state a claim.
But I don't think that's a requirement.
No,
if we
I'm just
oppose.
asking, but you did.
We did not, no.
Okay.
So the party expects to be in action, be a party to an action, and it can't presently bring it. Well, one of the actions that they allege is an action under 10-1604. If we refuse to comply with 1061 or 1601 at SEC, then the remedy for that is to file an action under 1604 to get the records that they're entitled to. Instead of doing that, they waited a year and they filed a Rule 27. But there was nothing preventing
Does
them.
Rule 27 say after you have exhausted all other possible remedies, you can come to us?
No, it does
It
not.
doesn't? Okay.
It does not. But the point is, it does say you can't presently bring the action. They could presently have brought an action under 10-1604.
But not the action that they were talking about, a different action.
Correct.
So you're saying, well, you could sue on this, but they are talking about different actions that are of concern.
If you look at the petition, Your Honor, they specifically argue that they're unable to bring the 10-1604 action. They cite that statute as something they can't bring. That's not correct. They also cite the fact that they can't bring a derivative action because they lack the information to craft a demand. Well, the information required for crafting a demand is a very low threshold under that statute. But more importantly, that runs afoul of the interpretation that Arizona courts will look to as persuasive of the federal courts that say this is not a substitute for discovery. This is, you have to have a cognizable action here that you're trying to bring. You can't use it as a fishing expedition. And by alleging that they don't have enough information to make a demand, they are conceding that they need this information in order to craft the complaint. And the federal authorities are very specific that that's not a proper use for Rule 27. Then when we get to D, for example. So one of the issues has been a little bit of a whack-a-mole problem in that the allegation is they wanted to bring a derivative action. Well, first off, they then talk about securities fraud. That's not necessarily derivative action. They don't need to bring a derivative action if they think they're defrauded. They could have brought that action. There are any number of actions that they could have brought. They never allege any facts. They simply allege generalities. They allege, we think that there's been malfeasance. What are the facts that the petitioner desires to establish by the proposed petition? That's what they're supposed to put in the petition. All they did was say malfeasance and absconding of funds. There's no factual allegation there. It's a category of things that they want to bring. Identify the name or description of each person. And this is where it becomes clear that they're shifting the viewpoint and shifting what it is they're arguing in order to try to hit the elements of each of these claims. They claim initially that we need this information in order to craft a demand. Well, that runs afoul of the federal authorities, and it's not preservation. That's simply we want the documents so that we can draft a complaint. That's improper under the federal interpretation of Rule 27. I think that Arizona courts ought to adopt the same thing. But then they say, well, we expect to be sued by one of our own investors for an investment that was in 2007.
That's what this all relates to,
Right,
is the investment in 2007.
Right, 18 years ago. Right.
But that's the core of the whole case. Your client is reimbursing money from that, and it's based on your client's decision on how it was going to buy back from that investment. So I don't buy much that it was 20 years ago.
Right, but that's what they allege in the reply. That argument doesn't appear until the reply when it comes to the issues of the stock buyback and that sort of thing. But the point that I'm making is if you look at Section D of this petition, they're supposed to identify the name or description of each person whom they expect to be an adverse party. What's missing from Section D in their petition is any mention of any third party that might bring a claim against them. The only people that are mentioned are the officers and directors of Dreambrands, and under A, they could bring that action if they wanted to. Under securities fraud, if it's unlicensed securities sale, which is another allegation that they make, they could bring that action without having to go through the demand. If they have a sufficient amount that it's a cognizable claim, then they could bring it. If they don't, it's a fishing expedition that's an improper use of Rule 27. And with that, I'd like to reserve my remaining minute and a half.
Okay. Counsel?
Good morning, Your Honors. May it please the Court, Louis Lopez on behalf of the appellee, Phoenix Actuary Home. I want to start specifically where counsel ended, and specifically our petition, page 4, lines 3 through 6, in which it was valid under penalty of perjury that the appellant did not have a record preservation policy in place, and the materials that we sought was specifically valid could be manipulated, deleted, destroyed by the appellant. Additionally, I'd like to bring your attention to page 7, line 17 of our petition, which we specifically stated that the information that we needed that was in the appellant's position was necessary to defend against any joint and several liability asserted against us under a promoter liability theory, which is at page 5 of our petition as well.
So what about the fact, and this is where he ended, the name or description of each person?
That was a new issue argued for the first time at the hearing, in which it would not address at any point in time. I stood up.
Well, there was no, everything really started at the hearing because there was no response.
At the conclusion argument, when Mr. says that the appellant made the argument, I stood up when they raised that issue. I told Judge Thorsten, my client is here. I'm avowing my client is ready, willing to testify and identify the specific individuals who are here in the threatened litigation. Judge Thorsten believed that was sufficient for purposes of the hearing under Rule 27. And that therein is the crux. Our position in terms of the abuse of discretion standard is appellant needs to identify for you specific evidence admitted at that hearing that establishes that as abuse of discretion for Judge Thorsten to make this decision. In the opening brief, they have not cited to you any specific evidence. In the reply brief, they have not. When you look at the history of what happened here, we submitted a verified petition under penalty of perjury. They filed a response. They filed no controverting affidavit. They filed no controverting declaration. They submitted no alternative form of evidence to a declaration or an affidavit. Similar to a Rule 56 motion, they didn't do that.
So what they're stuck with is a facial challenge to the petition.
Absolutely, except in this particular case, because Rule 27 gives the individual an opportunity to request an evidentiary hearing, they could have presented evidence.
It doesn't say evidentiary hearing.
A hearing, you are correct. Fair enough, Your Honor. They requested a hearing.
Well, they didn't have to request it.
They didn't have to, but they did. And so we had that hearing at the appellant's request. Judge Thorsten started that hearing by asking the parties whether or not either one of them wanted to present evidence. We said no. Our petition was uncontroverted. She gave the appellant the opportunity. The appellant said no. We had argument at counsel. This court knows the argument at counsel is not evidence. With respect, what appellant has argued here today, procedurally in terms of what happened here, what happened there, none of that was presented to Judge Thorsten below.
But does Rule 27 talk about meeting some particular evidentiary quantum in order to allow this discovery? Does it talk about the balancing of evidence? It's not similar to, for instance, like a motion for summary judgment where we have to see if there's a disputed issue of material fact. This is essentially a discovery dispute, isn't it?
It says in part, yes, it's a preponderance of the evidence. Have we presented sufficient evidence to meet the elements for Rule 27?
Where do I find preponderance of the evidence in Rule 27?
Your Honor, admittedly, there is no case law in terms of identifying the evidentiary standard. That's fair enough.
Isn't it a showing? I'm not sure what a showing means. So what is the showing necessary under Rule 27? And I don't know that it's, and I understand the specific elements, but the showing, what is it?
The showing in terms of the four elements that counsel has gone through in terms of what's necessary, reason for preservation, et cetera. We did present those four elements for purposes of showing. We presented admissible evidence. This was not a fishing expedition because we presented admissible evidence. Admittedly, there is not a case that specifically says it's a preponderance of the evidence, but we satisfied from an evidentiary basis that there was, in fact, good cause for this pre-litigation
Do we
subpoena.
impose a preponderance standard in any of the other discovery statutes, or is it just a showing?
It's just a showing. It is just a showing, Your Honor. And again, it goes back to at the hearing itself, appellant had the opportunity to stand in front of Judge Thorsten and say, hey, that statement in the verified petition is inadmissible because it lacks foundation, or because it's hearsay, or for whatever reason.
So it's not a sufficient showing?
Correct.
Is what it comes down to. It's
Exactly.
not a sufficient showing.
Exactly. And so you are left with a situation where it's an abuse of discretion standard, and yet you have nothing in front of you to show that Judge Thorsten in any way abused his discretion in making the findings and decided what he did. As Your Honors pointed out, appellant did not ask for findings of fact and conclusions of law. Neither did we. So Judge Thorsten was not required to do that. Judge Thorsten made a well-reasoned decision in terms of what happened. More importantly, as part of the verified petition, we did in fact attach the proposed subpoena and the documents that we wanted. That was in front of Judge Thorsten. They had an opportunity to raise that issue in front of Judge Thorsten. They didn't object to the subpoena. They didn't argue the subpoena was overly broad.
But doesn't the rule talk about that they retain all the defenses that a third party would have to a subpoena? For instance, even after the Rule 27 petition is granted and the subpoena is issued, they can still object that it's unduly burdensome or that it's overbroad. They still have all of those defenses to the subpoena itself, don't they?
So I'm going to answer that argument in twofold. Respectfully, that issue is not before the court. And so we don't want to talk about things in hypotheticals. Second of all, in terms of our interpretation, no. With respect, and this is frankly from a procedural history, when Judge Thorsten issued the subpoena, they didn't respond to the subpoena despite service. We got bogged down in some procedural aspect as to whether or not they were in violation of that subpoena. And at the end of the day, Judge Thorsten said, we're not addressing that because we're going to let the appellate court first decide whether my decision was proper or not. But I will agree with you that the distinction between Rule 27, 45.2, and the statute they cite to is under Rule 27, the standard is Rule 26 for discovery. Is the information that we want under Rule 27 in the subpoena proportional? Is it unduly burdensome, etc.? Under a Rule 45.2 standard, there is no mechanism for discovery. It's simply preservation. So the distinction between 27 and 45.2, 27 gives us the specific mechanism to seek discovery under Rule 26. 45.2 is the mechanism if you're trying to preserve evidence with a party or non-party, and then it gives a party to go and file an objection under Rule 26D, or a non-party to file a petition like you have similarly in Rule 27. So they perform totally separate functions. Same with respect to 1604. You file a 1604 with respect, you're pregnant in litigation. It is full-blown complaint. You do complaints, you do disclosure statements, you do affirmative defenses as whether or not the material falls within the four categories. You argue about whether or not it's being asserted in good faith or bad faith. It's a full-blown litigation. I'm sure your honors have presided over those full complaints. Rule 27 is supposed to be a clear, efficient way for you to go and obtain pre-litigation discovery of information that is at risk of being destroyed or not being preserved to allow you to defend yourself against claims that are forthcoming and not be dependent upon someone that exclusively controls that. And so long as you meet the standard of Rule 27, then you trigger to Rule 26 and you have a decision as to whether or not the subpoena is overbroad or whatever. But that's the way this is all harmonized and it all works together. So when counsel starts his argument by saying that Rule 27 is a challenge to the legislature, and your honor hit the nail right on the head, this is not a constitutional issue. They all read in harmony with one another. Rule 27, again, by way of analogy, is almost like getting a prejudgment provisional remedy. You do that, you file your verified petition, you have an option to request a hearing or not, you present all your evidence, and the judge makes a finding as to whether or not you meet the standard and you go forward. We do this all the time, and it is a quick, efficient way to avoid parties from going into absolute litigation fees costs. And so where I'll end is where I started, and where Your Honor started is, it's abuse of discretion standard. And they were given an opportunity to present evidence controverting our verified application. They were given an opportunity to present evidence to Judge Thorsten at the hearing, and they didn't do it. And unless they can identify for you something specific fact or evidence in the record that establishes that it was an abuse of discretion for Judge Thorsten to do what he did, Your Honor shouldn't touch it, and you should affirm the decision.
So let me ask you, he argued that your petition didn't meet A because you were on a fishing expedition, it wasn't matters that you couldn't bring. What matters couldn't you bring at this time? And not just because you don't have the evidence,
Sure.
but you couldn't bring them at this time.
Sure.
Or somebody couldn't.
Sure. So specifically, again, as we set forth at page 5, we were the initial individuals that went out and solicited investors in there, and we have concerns about promoter liability and security liability and et cetera. At the end of the day, we have to defend against those claims. We're entitled to indemnification against the appellant. Those are the type of claims I could not, that's the wrong words, the appellees could not file a declaratory judgment action and ask the court to declare that the appellant would have to defend and indemnify my clients against promoter liability or to produce this particular material. Why? Because the standard for declaratory relief is an actual judicial controversy, which is a higher standard than what the standard is under Rule 27. So that is a specific example of a particular claim. Understand the petition is almost like a Rule 8 pleading, to your Honor's point, is it's not supposed to be the end-all, be-all book of Genesis. It is to give the party notice of potential issues out there. And what appellant is trying to do is shoehorn us into one particular issue and ignore all the other issues that we put in the verified petition, such as this promoter liability. We brought that issue to Judge Thorsten's attention. Judge Thorsten agreed, looked again at the verified affidavit or petition, saw that there was no controversy in the affidavit, and agreed that we had met our burden. We would be here in an entirely different scenario if they had presented some type of controverting evidence, either declaration, affidavit, or testimony, but they didn't. And so they are limited to the four corners of what is pled in our application. And if you accept those factual statements, starting with the two statements I read to you at the beginning, there is no question of fact, and that's the wrong standard, I know that, but there's no question in terms of Judge Thorsten, what was in front of him is that they did not have a mechanism in place to preserve this data. And then he had this uncontroverted evidence that this data could be freely manipulated, changed, or deleted by the appellant. And then the evidence that we needed that to defend against that liability.
Let me ask you about a different section. Because you on behalf of your client, you offered to have someone testify. You identified that person, I believe, by name. Did you identify that person by name in your petition, or at least describe that person? Because that's subsection D. And you're saying, hey, we had this person there who could testify, would have had him testify. Was that person identified again, either by name or by description?
It was, Your Honor. It was the same individual that signed the verification to the petition. He was there at that hearing ready to go. And he was identified, and it was specifically identified to Judge Thorsten that he was there and prepared to testify.
In the petition, where was he identified?
He signs the verification.
I understand he signed it. Is he signing it as the person who expects to be an adverse party? That's what needs to be there. Is he expecting to be an adverse party? Is that what the petition says?
So again, that's a loaded question because he's an individual and it's the company that invests in it. He did sign the verification to the petition avowing under penalty of perjury that he has personal knowledge of the factual statements therein. He was authorized to make those statements on behalf of the company.
But the rule requires that you identify the name or a description of each person whom the petitioner expects to be an adverse party.
Oh, I'm sorry.
I'm asking you.
I apologize.
Does the petition identify him as the adverse person or describe him?
Yes, I apologize, Your Honor, I misunderstood.
okay.
Yes, we do in fact identify the individuals, the officers of the companies that we expected to be adverse to. Yes,
Okay.
we did. I
Yeah, I
apologize
just
for
want to make
misunderstanding.
sure that that was covered, because there was, some suggestion that it's all about the derivative action, and that's
No.
not the same
No,
thing.
correct. Those individuals are in fact identified. We did put them with specificity, including the location and their addresses as the Rule 27 required. And as I said, the individual that was prepared to testify in front of Judge Thorsten to address this new issue that came up in argument is the same individual who verified the petition. So we were ready to go in terms of doing all this aspect of it. It's just counsel chose not to contest any of the factual statements contained in the petition, and now the appellant is surprised as to why Judge Thorsten believed we met our standard. They shouldn't, because if they had evidence and believed that we did not meet the standard of Rule 27, then they should have presented it when Judge Thorsten gave them the opportunity to do so, and they chose not to do so. And again, I keep circling back for purposes of your standard, because that's what Your Honor asked, having sit on the bench. What is the evidence in the record that allows you to find that it was abuse of discretion for Judge Thorsten to do what he did? The answer is nothing, because there is no citation to any evidence in the record that the appellant presented that establishes that that decision was an abuse of discretion. So again, unless Your Honors has any other specific questions that you have of me, I respectfully request that Your Honors affirm the decision.
Thank you.
So let me go back to Louis taller than I am. Let me go back to the Section D question that you asked Mr. Lopez. The individuals that are listed in Section D are all of Dreambrands officers and directors that would be defendants in a proposed derivative action, securities fraud, any of the number of additional actions that he could have brought instead of bringing a Rule 27 petition. What are not listed in Section D are any of the proposed third-party investors that might sue both Phoenician and Dreambrands, and that's the hook that he's hanging his hat on when it comes to not being able to bring the action and the proposed threatened litigation. That's what's missing from this petition. I would point out as well that this is about, and this is where we can't get lost in too much in the weeds, Rule 27 is about the preservation of evidence. It is not about conducting discovery in order to craft a complaint, and that's all that has been shown. As far as burden shifting and evidence, our position is the face of the petition defeats itself. You can't aver that both the light is green and the light is red and say, well, you've got to take our facts as true when you have inconsistent positions here. Finally, for preservation, we're a potential adverse party under Sousa. Now that we know he may bring an action, we are required to preserve the evidence, or else we're subject to spoliation defenses. It is unnecessary for Phoenician Equity to get the documents in order to preserve them. Thank you.
Thank you, folks. We appreciate your argument here today. We'll take the matter under advisement and issue our ruling in due course. We're going to stand adjourned while we set up for the next oral argument.